Bless you. Court calls the case, People versus Samira Smith.
Here's a simpler version. From the very beginning, this hearing feels more serious than a normal court appearance. The defendant is young. The public defender quickly talks about waiving the preliminary examination, and the judge moves the case along smoothly and efficiently. If you're not familiar with court procedures, it's important to understand that waiving a preliminary examination does not mean the defendant is admitting guilt. It simply means the defense is not challenging the evidence at this stage and is allowing the case to move directly to circuit court. This often suggests that discussions are taking place behind the scenes. Both sides are likely weighing their options, considering possible plea deals, potential sentences, and the risks involved. Pay attention to what the defense attorney says. They mention that there are no offers yet, but discussions are still ongoing. In simple terms, that means no agreement has been reached, but negotiations are continuing. That uncertainty is important because without a deal in place, many things remain undecided, including bond decisions, future charges, and whether the defendant will remain in custody. It's also worth noticing Judge Simpson's approach. He stays calm, professional, and focused on procedure. There's no drama yet, but judges often reveal a lot through their actions rather than their words. Right now, he's allowing the attorneys to establish the facts before taking a closer look at issues like credibility, risk, and responsibility. And that deeper examination is likely coming soon.
Senior Assistant Public Defender representing Ms. Smith. Ms. Smith, would you please state your name?
Thank you.
Your Honor, at this time, Ms. Smith will be waiving the preliminary examination. She is aware that there are no offers, but we are continuing to discuss matters with the prosecutor and are also hoping to be able to work out a COTS agreement. Is that correct, Neil?
All right. You understand that the preliminary examination is a proceeding where the people would have to show by probable cause that the offense was committed and that you committed it. You understand that, ma'am? And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Okay.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on the single Ms. Gaines.
Your Honor, we acknowledge receipt of the information, waive its reading on the record. At this time, my client wishes to stand mute and have the court enter a not guilty plea.
Defendant having waived reading standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
August 12th at 1:30 before Judge Slay Monday.
August 12th, 2024, 1:30, Slay Monday.
Your Honor, may we address bond, please?
Right.
Your Honor, my client is a young woman. She's 20, just barely, just soon to be 21 in a few weeks. She has had a very challenging past few months. She has been, she recently had a son who is about a year old now. Her mother died unexpectedly in April of this year. And she has just had a very hard time financially, emotionally.
This is one of the most important moments in the hearing because the defense is no longer focused on arguing the facts of the case. Instead, they are trying to show the judge the defendant's personal struggles and circumstances. Listen closely to what the attorney is doing. They are building a picture of someone facing major challenges, a young age, a recent pregnancy, emotional difficulties, financial problems, the loss of a mother, and past legal issues connected to personal hardship rather than violence or danger. The goal is to convince the judge of one thing. Is this a person who deserves a chance to remain out of jail? On an emotional level, the argument is powerful. The defendant is only 20 years old, has a 1-year-old child, faces housing concerns, has probation issues, and relies on family members who are trying to help. It creates the image of someone struggling to keep their life together. However, the legal challenge is that sympathy alone does not remove concerns about risk. Judges must balance compassion with factors such as public safety, the possibility of missing court dates, probation violations, and any pattern of repeated offenses. What makes this moment especially difficult is that the defense argues the defendant has stability through housing assistance, family support, and childcare, while also acknowledging probation holds in another county. That creates a conflict in the argument. From the judge's point of view, if someone is already being supervised by the court system and still returns to criminal court, it can raise concerns about reliability and accountability. This leads to a larger question. Should personal hardships and tragedies reduce a person's legal responsibility, or does a history of repeated legal trouble eventually outweigh those circumstances? This is often the point where people watching a case have very different opinions.
And it's manifested in many different ways, which includes having had some prior trouble in Oakland County before this, for which she is on probation. And we do believe that there are holds for Oakland County. We are asking, however, that the court consider giving her a bond that she could post. We're asking if the court will not consider a personal recognizance bond a $1,000 cash or surety bond, so that she can get to Oakland County and begin to resolve those matters as well. My client, as I said, has a 1-year-old son. At this time, her 85-year-old grandmother and her older sister are looking after him. But she does have Section 8, which is of great value to her and her son. And she would like to be able to keep Section 8, and an extensive amount of incarceration will impact her ability to do that.
Ms. Gaines, is she on probation on 9 offenses out of Oakland County?
I think it's 2 cases and between them the 9 counts. So yes, I am saying correct. I just don't know the number of counts. I knew the number of cases.
Okay.
She does have family support. Her cousin, David John, is here in the courtroom. He indicated that her grandmother is trying to get here, and she would return to her address in Detroit, where she does have the voucher and would be able to take care of her son upon completion of the Oakland County matters, she hopes.
Did she violate on the Oakland County matters?
I do believe that there is a violation of probation, holds out of Oakland County as a result of this matter.
And there it is. The moment that seriously weakens the defense's argument for a lower bond. Up to this point, the defense attorney had been presenting the defendant as someone facing difficult circumstances but still capable of getting her life back on track. They highlighted her young age, her role as a mother, family support, housing assistance, and personal hardships. But the mention of probation violations changes the situation dramatically. The reason is simple. Probation is already a second chance. When someone is on probation, the court expects them to follow specific rules and conditions. Once the judge learns that our probation violation hold connected to the current case, the focus shifts. The question is no longer, can she get back on track? Instead, it becomes, can she be trusted to follow court orders? That difference is significant. Notice how quickly Judge Simpson responds after hearing this information. He doesn't give a lengthy explanation or show emotion. He simply denies the request for a bond reduction. The speed of that decision is telling. In many court proceedings, when a judge rules immediately after hearing a key fact, it often means that fact strongly influenced the outcome. This is one reason defense attorneys are especially concerned about probation issues. Probation violations can affect nearly every part of a case, including bond decisions, sentencing, credibility, and arguments for rehabilitation. It's also worth noticing how calm the courtroom remains despite the importance of the moment. A decision that could greatly affect a young mother's freedom is made in just a few seconds, without drama or lengthy discussion. That's one of the realities of criminal court. Some of the most important decisions in a person's life are made quickly, based on a few critical facts and the judge's assessment of risk, responsibility, and trust.
I don't necessarily need anything from the people unless you want to say something. Motion for bond reduction is denied. Bond will continue.
Thank you.
A plea agreement, and that form should have been tendered to Your Honor and to defense counsel.
I do have it. The form indicates that the defendant will be pleading guilty to child abuse, 4th degree, punishable by up to 1 year, up to 5 years probation. And upon a successful plea to that charge, count 1 would be dismissed. There is no other agreement.
That is correct, Your Honor. Awesome.
John Matthew Carlson.
Has he signed an advice of rights form, counsel?
Not to my knowledge, Your Honor. I can have him sign one right now.
Have the defendant sworn, please.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
John Matthew Carlson.
Sir, it is this court's understanding that you're going to plead guilty to the charge of child abuse, 4th degree. That is a misdemeanor punishable by up to 1 year incarceration and up to 5 years probation. Is there a maximum fine on that? Mr. Reiser?
I don't believe so. 1 year or probation or up to
5 years, no maximum.
1 year
All right.
jail or probation up to 5 years, no monetary.
Gotcha. All right, you understand that, sir?
Yes, sir.
All right. And you also understand that pleading guilty in this case, that I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right, understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Here's a simpler and more natural version. Now the hearing moves into a completely different stage. The focus is no longer on bond decisions or negotiations. Instead, we're watching the defendant give up important constitutional rights by entering a guilty plea. Many people misunderstand what a guilty plea actually means. It's not simply saying, "I did it." A guilty plea means giving up several major legal rights. The right to a trial is waived. The right to confront and question witnesses is waived. The ability to challenge the case on appeal becomes much more limited. At that point, the case usually shifts from proving guilt to determining the punishment. That's why Judge Simpson is being so careful. Before accepting a plea, the court must make sure it is made knowingly, voluntarily, and with a full understanding of the consequences. This is why the judge asks similar questions repeatedly. Were you threatened? Were you promised anything? Are you making this decision freely? To viewers, those questions may seem repetitive, but they serve an important legal purpose. The court needs a clear record showing that the plea was made willingly and without pressure. If that record is incomplete, it could create problems later. There's also another reason this hearing feels especially serious. The charge involves alleged child abuse. Cases involving children often carry a much stronger emotional impact than many other criminal cases. Even though the defendant remains calm and respectful throughout the hearing, everyone in the courtroom understands that the stakes are extremely high. The moment a case involves a child, the legal issues are often accompanied by strong moral and emotional concerns, making the atmosphere noticeably heavier.
You had signed an advice of rights form today, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see it on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
February 20th, 2024, at the location of 3137 Homestead Commons, Apartment 5, Ann Arbor City, Washtenaw County, State of Michigan. Did you have care or custody of a minor child?
Yes, Your Honor.
And what did you do with reference to that child?
I hit him in the arm with a closed fist.
All right. How old was the child?
10 years old at the time.
All right. And in doing so, you were doing something in excess of discipline?
Yes, Your Honor.
And that did, you would admit, cause physical harm to that child?
Yes, Your Honor.
I'm sorry, I didn't hear the initial factual basis for the plea.
Which part?
What did he say he did to the child?
He said he hit the child with a closed fist in the arm.
Okay, so if I could just read and make sure that this is correct for the record, the police report, Sean approached Anthony, the minor child, and punched him with a closed fist in his face, causing his head to snap against the wall. Is that correct, sir? Did that happen?
That's not what happened.
Okay, there's a big difference between the arm and the face.
This is the moment when the plea hearing suddenly becomes much more complicated. Up until now, everything had been moving smoothly. The defendant's rights were explained, the plea was entered, and the court was establishing the facts of the case. Then the judge noticed a major difference between the defendant's version of events and what was described in the police report. This wasn't a small detail. The disagreement involved the nature of the alleged assault. According to the defendant, the child was struck in the arm. According to the police report, the child was punched in the face hard enough for the child's head to move backward. That difference is important because judges need an accurate factual basis before accepting a plea. If a defendant downplays what happened while the evidence suggests something much more serious, the court has to address that issue. Judge Simpson immediately focuses on the inconsistency, and the atmosphere in the courtroom changes. His questions become more direct, the defense adjusts its approach, and the prosecution becomes more attentive. What had seemed like a routine plea hearing suddenly becomes uncertain. What makes the situation especially difficult is that the defendant does not completely deny the incident. Instead, he disputes parts of what happened. That creates a challenge for the court because two different versions of the same event are now being discussed during the plea hearing. When that happens, the judge must decide whether there is enough agreement on the facts to accept the plea or whether further clarification is needed. This is one reason defense attorneys sometimes prefer a no-contest plea in sensitive cases. A no-contest plea allows the defendant to resolve the criminal charge without making detailed admissions about exactly what happened, which can help avoid disputes over specific facts.
Yes, sir. I do believe it's a sufficient factual basis, however.
Was his nose bleeding when the police arrived, sir?
No,
Your Honor, would the court accept a no contest plea?
I don't know if the deal was contingent upon him pleading guilty, but obviously we have two very, very different versions of what happened. I mean, either the child got hit in the face or the arm, and either the child was bleeding or he wasn't. Do this. Why don't I pass the matter? Counsel, why don't you talk to your client?
Yes, Your Honor.
And then I'll call you guys back up and let's see what we can do.
Thank you, Your Honor.
Thank you.
Senior advisor again on behalf of the people, Your Honor.
Assistant Public Defender Davy Lieb on behalf of Mr. Carlson. It stands to my right. Mr. Carlson, can you state your name, sir?
Sean Matthew Carlson.
Thank you for the court's patience, Your Honor. I have had additional discussions with Mr. Carlson about the conversation with the prosecutor. At this time, Mr. Carlson would like to enter a no contest plea.
Do I have? Oh,
I don't have an objection to that, Your Honor, and I have marked the police report as People's Exhibit 1 in our Police Department report 24-7818 and marked the injury to the child and the relationship and the statement from the report. And ask that be admitted on the basis of.
any objection, counsel, to the court reviewing this report?
No objection, Your Honor.
That being 24-7818 of the Ann Arbor Police Department.
And just like that, the entire strategy changes. After the earlier disagreement over the facts nearly disrupted the plea hearing, the attorneys took time to discuss the issue off the record. When they returned, the defendant changed the plea from guilty to no contest. That change is very significant. A no contest plea allows a defendant to accept a criminal conviction without formally admitting the allegations in open court. In this case, the court specifically discussed two reasons for using that type of plea: the defendant's claimed lack of memory and concerns about possible civil liability. The issue of civil liability is especially important. When allegations involve injuries to a child, criminal charges may not be the only legal consequence. A civil lawsuit could also be filed, and statements made during a criminal hearing can sometimes be used as evidence in later civil proceedings. A no-contest plea can help avoid making detailed admissions that might create additional legal problems. Once the revised plea agreement is presented, the hearing becomes much more procedural. The police report is entered into the record. The judge reviews it, and both attorneys confirm that they have no objections. Everyone involved is working to create a clear legal basis for the plea after the earlier dispute over what happened. Even though the plea process gets back on track, the earlier inconsistency is hard to ignore. The disagreement over the facts raise questions that do not simply disappear because the plea format changed. This highlights an interesting reality of courtroom negotiations. A case can be resolved on paper, and the legal process can move forward, but concerns about credibility and trust may still remain. Sometimes the agreement survives, but the doubts created during the process do not completely go away.
Sir, the understanding is you wish to plead no contest?
Yes, Your Honor.
The basis for the no contest plea, counsel?
Lack of memory as well as potential civil liability.
Okay. You understand that all the rights that I explained to you apply to a no contest plea?
Yes, Your Honor.
And everything is exactly the same. It's just that you are pleading no contest to the charge. You understand that?
Yes, Your Honor.
So to that charge, how do you plead?
No contest.
Review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of the defense counsel. Have I complied with the court?
Yes, the people are saying.
Defense is likewise satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
August 30th at 9:30 before Judge Terry.
August 30th, 2004, 9:30 before Judge Perry.
Your Honor, you could just check on the form that it was a no contest plea, and the one other additional part that I believe was discussed between parties is there will not be a delayed or a deferred.
Is that correct?
That was discussed, Your Honor.
Well, was it agreed to?
In terms of my discussion with Ms. Willenbring, I believe I just asked if she would be offering one. I don't know that we necessarily agreed that we would not be seeking one. However, that may have been a discussion with the previous attorney.
What?
That may have been a discussion with the previous attorney on the case.
And so just maybe a miscommunication. No, we're not offering one means that the reduction happens and we're not offering it and he's not seeking it.
And that is correct.
This part of the hearing may seem routine, but it actually highlights an important issue being worked out behind the scenes. The discussion focuses on whether the defendant could receive a delayed or deferred resolution. In some cases, these arrangements can help a defendant avoid certain long-term consequences if they successfully complete specific conditions set by the court. For a moment, however, the conversation becomes unclear. The defense attorney refers to earlier discussions. The prosecutor quickly disagrees, and the judge steps in to make sure the record is accurate. That matters because judges want plea agreements to be completely clear. There can be no confusion about what is being offered, what is not being offered, what rights are being given up, and what consequences the defendant may face. If there is any uncertainty, the court must stop and clarify everything before moving forward. Eventually, everyone agrees on one important point. There will be no delayed or deferred arrangement in this case, and the defendant understands that. This means the plea has immediate legal consequences. There is no special program, future dismissal, or alternative resolution waiting in the background. The conviction and its effect will proceed under the terms of the agreement as it stands. Even after that issue is settled, Judge Simpson continues to focus on something that clearly remains a concern: the conflicting descriptions of the child's injury. Although the plea agreement has been resolved, The earlier inconsistency has not completely disappeared from the judge's mind. The disagreement about what happened raises questions about credibility and the accuracy of the facts, and those concerns can still influence how the court views the case moving forward. In many hearings, a plea agreement may settle the legal issues, but it does not always eliminate the judge's concerns about the underlying conduct. The child's safety and the conflicting accounts of the injury appear to remain at the center of the court's attention.
So that is correct.
Yes, Your Honor.
He's not going to be seeking delayed or deferred.
That is correct.
You understand that, sir?
Yes, sir.
Thank you.
He's not around this child currently, is he? I mean, probably the worst thing is he told me something. I'm looking at the police report. He's telling me he hit him in the arm. There's a clear injury to his face. And
I know that CPS is involved. I would like to think that they remained involved, although I don't know that for certain.
He did complete a reunification process through CPS, Your Honor.
And so what's the status currently?
The child is residing with Mr. Carlson. Under the guidance of Child Protective Services.
What's that mean?
He completed a reunification process. My understanding is that they maintain some involvement.
Okay, so what is that involvement?
Just recently, my CPS social worker just closed the case out just early July. Since then, I've also been going through a lot of parenting classes, and I'm going through some other things through affiliates of with protective services, with like orchards and other.
Are you taking parenting classes now?
I completed mine. It was a 10-week course.
Pardon?
It was a 10-week course.
And so you're doing, there is nothing, the child is just with you.
Yes. And protective services thought it was still okay for him to be with me.
I've got some serious concerns with a man that can't realize that he didn't hit a child in the arm, but hit him in the face, and coming before a court and telling me that. So you're lucky to be leaving today. You may leave.
Thank you.
Here's a simpler and more engaging version. The final part of the hearing is especially revealing because Judge Simpson shifts his focus from legal procedures to something much bigger: character, responsibility, and future risk. The defendant explains that he completed parenting classes, CPS is no longer involved, and he has already been reunited with the child. On the surface, those are positive developments. They are exactly the kinds of steps courts typically want to see when someone is trying to demonstrate rehabilitation and personal growth. However, one issue continues to concern the judge: the defendant's description of what happened. Throughout the hearing, the defendant maintains that he struck the child in the arm, while other evidence suggests the child suffered a facial injury. That difference remains difficult for the judge to overlook. The most important moment comes when Judge Simpson openly states that he has serious concerns about a person who continues to insist the injury happened one way despite evidence suggesting otherwise. This isn't just a routine comment. It signals that the judge questions whether the defendant has fully accepted responsibility for his actions. At the same time, the judge also recognizes the progress that has been made. The parenting classes were completed, CPS involvement has ended, and the defendant has followed the required steps. In the end, the defendant is allowed to leave, but the outcome is far from a complete victory. The judge acknowledges the rehabilitation efforts while also expressing concerns about credibility and accountability. That balance is what makes cases like this so complex. Courts are often asked to weigh progress against past conduct, rehabilitation against responsibility, and hope for the future against concerns about safety from beginning to end. This hearing became a mix of legal negotiations, disputed facts, rehabilitation efforts, and child welfare concerns. Judge Simpson's decisions reflected all of those competing factors. That if you found this courtroom breakdown interesting, be sure to like the video, share your thoughts in the comments, and subscribe for more detailed courtroom analysis and case reviews.